I understand that the industry is concerned about costs, because the sum awarded can be rather high at times. The industry has proposed that the sum awarded be capped at $20,000. And then another suggestion is that a ruling should be given in writing. In other words, there can be the lodging of an appeal in writing, and the handing down of a ruling in writing. In other words, there will not be a need for the two parties to hire lawyers to address the tribunal. Chairman, concerning the awarding of costs, that's a discretion that will be enjoyed by the IAT, and both parties will be treated fairly by the tribunal. And the IAT will decide whether to award costs and the sum awarded in accordance with Order 62 of the rules of the High Court. In other words, the tribunal will have to make sure that no one has deliberately caused delay and has abused the procedures or the proceedings. So the IAT, the chairperson of the IAT, will exercise the discretion fairly and decide whether costs have to be awarded. An appellant has the right to have legal representation, but then legal representation is not a must. And so parties aggrieved by the IIA's decisions do not necessarily have to engage lawyers to represent them.
Also, there are cases where elsewhere tribunals take into account the financial condition of one party. So even if that party loses, he does not have to bear the cost. So the chairperson will make a reasonable decision as for whether there can be a written decision. Now, if you look at the provisions, there are provisions whereby the appeal decision can be reached fairly, quickly, and economically. And if both sides agree, the chairperson can make the decision himself without having two members as well. So this would save some procedural work. This has to be agreed by both sides. You have not responded whether it's 20,000 and whether a written representation is permitted. Let me directly respond. We will not consider setting an upper limit. We will not curtail the discretionary power of the chairperson of the tribunal. In the provisions, there's no provision saying that the representations cannot be in writing, but it does say that the chairperson can decide the form that the representation can take. Now, the Federation suggested that you accept written representation. Now, I can provide you with the text and you can consider the wording concerning the presence of a lawyer. We can consider that, yes.
There will be a chairperson and there will be a panel of members. I want to know whether the panel of members will be recommended by the FSTB, and will the FSTB make sure that the panel of members possess knowledge and expertise in the insurance industry. And then concerning the cost, I and Mr. Wong Yok Man have proposed a cap. You have told us that para 9A to D represent the circumstances under which costs are awarded. But that doesn't mean that if a party hasn't committed A to D, then he will not have to pay the cost. And then even if the appealing party doesn't hire a lawyer, the IIA may be represented by a lawyer. Yes, Chairman. Concerning the panel of members, it will be appointed by the CE. The bill doesn't include any prerequisites for being members, but then the panel will definitely comprise professionals and people from the insurance sector. This is because actuarial, accounting, legal, and insurance issues will definitely come up in the IAT. So there will definitely be people from the insurance sector sitting on the panel, and there isn't a ceiling for the number of members on the panel. But then every time a tribunal is convened, there will be an appointment process. That is because, say, if the case involves insurance company A, then a panel member who is from insurance company A can't be a member of the tribunal. And then, now 9A to D may not be exhaustive. Every time the chairperson makes a decision taking into account the behavior and the conduct of the parties concerned. But then every time the chairperson makes a decision, he needs to refer to Order 62 of the Rules of the High Court. The member said that although the appellant might not be legally represented, the IIA might be legally represented. And so if the appellant lost, he really might have to pay the costs for the IIA. Because the paper states very clearly that if one party loses, then he runs the risk of paying the cost. So can you give us a rough idea concerning the sum? Or can you tell us more about how costs are awarded? If you because I think it's important that you try to allay the worries of the people, and if you are not in a position to give the information, perhaps the DFJ can assist. And then now some say that for SFC cases, they are more complicated, and so there is definitely legal representation, and also the parties concerned are many companies. But then here we're talking about many individuals. There are about 80,000 intermediaries who are individuals, and how can you allay the worries of these individuals? Thank you, Chairman. On the SFC, I want to say that there are also individuals who are licensees, and in fact, individuals have lodged appeals against the SFC's decisions. In fact, it's up to the parties to decide whether to get legal representation. But I want to make it clear that the chairperson will make a decision in a fair and impartial manner. In fact, in another tribunal, the chairperson did decide that there was no need for one party to pay the cost of another party. Perhaps the DOJ can supplement. The Deputy Secretary has already referred to Order 62 of the Rules of the High Court. And in fact, the factors are listed under Parent 9. So it's difficult for me to tell you how the courts exercise their discretion. But basically, they have to follow Order 62 of the Rules of the High Court. But for those who haven't committed any acts under 9 ABCD, does it mean that they will not have to pay the cost? No, these are the factors that the courts consider. But of course, the courts have the discretion. So, it seems that even though a party hasn't committed A, B, C, or D, he may still have to pay the cost. And I've heard that individuals have decided not to appeal against SMC's decisions. In fact, I know a person that you know as well, and he said that he was lucky that the company would pay for the cost for him, or else he would not have decided to appeal against the SFC's decision. I think it's important that you allay the worries of the individuals. You know that now individuals really dare not appeal against the SFC's decision. I think it's important that individuals. I think it's important that individuals will not be deterred to lodge appeals because they are worried about the cost. And then for the AAB, in fact, no costs are awarded, but then there can be legal representation. So can you follow this model?
So the cost would not be involved. Would that be feasible? Now, this is just one more thing for you to think about. Now, even if you provide an answer to me, the industry might still be worried because they see the situation as at the SFC. Please consider how you can reassure the industry. Now, on the worry about the cost, we have heard this many times, but I must point out a fact. Now, under the self-regulatory framework, there is also an appeal mechanism on a disciplinary action, and the mechanism says that if there is cause to be decided, that to be determined, then the ruling would be made according to the court rules. It doesn't specify Order 62 of the High Court rules, but I believe that's the case. So this worry is also applicable to the current self-regulatory mechanism. Now, I have kept reiterating just now, this is a mechanism fair to all parties, because under the current self-regulatory mechanism, there are some cases where the complainant is determined to be to have engaged in the appropriate conduct, and he engaged in tactics to delay the procedure, and he incurs high legal costs, and the self-regulatory body engages a barrister to arrive at the cause and try to recover the cause from him, and there's difficulty. So we try to improve this. Now there is an independent IAT with the power to recover the cost. So the principle is that one must be fair to all parties. Now, para 9 says that Order 62 of the High Court rules stipulates certain conducts. Now, is that when the tribunal tries to determine the cause, the tribunal has to determine these factors. Now, whether the delay tactics have been employed, so on. So the chairperson will consider these factors in arriving at the cost to be awarded. Finally, I don't think we should always cite the SFC example. It's not quite appropriate. Now, the IAT will have regard to the financial circumstances of the party, and there are cases in the current mechanism where the party doesn't have to pay the cost. I think I go on to para 14. There it says that if one applies for appeal, there won't be a stay of execution. If he wants to have a stay of execution, one has to apply to the tribunal. I believe that understanding is correct. Now, if he applies, if he doesn't want the execution right away, he can apply for a stay. Now, when the application is received, the tribunal has to approve it first before there is an actual stay. Now, is there enough time for the tribunal to make a decision, or would there not be enough time because the execution is due already? Yes, in applying for stay of execution, the IAT chairperson can make a decision by himself. The two other members are not necessary for that decision, so a quick decision can be made. Now on the time limit, now the policy is that the process has to be quick and fair, so the person would not suffer injustice. The chairman, the design of the provisions are such that the chairperson can make a decision on the application for appeal, so it can be very quick. On the tentative timeline, is it that at stage 2 or stage 3 that the SROs will be superseded? Now, the members will they be qualified to take exams with the IA, and if they do not qualify, would there be arrangements for them to leave their jobs. Now, the FSTB has already set up a working group to discuss with the insurance sector about this issue. Now, the 3 SROs are represented in this work group, and there are also representatives of insurance intermediaries and agents. Now, so stage 2 is not yet in place. Now, the new IA will take over the work of the OCI. Now, the new licensing system will take the place of the regulatory system. Now, for the new licensing system, there have to be codes of conduct, and there will be penalty guidelines. They have to be seen by the industry before the the SRO being the work being taken over, that will occur in stage 3. Now, the jobs at the IA are by open recruitment. Those who are experienced when they apply for the IA jobs, they will enjoy an advantage, but we can't guarantee that all the staff at the 3 SROs will be taken on by IA. Now, the 3 SROs have to make an arrangement. We already have a working group in close contact with the SROs so that the transition can be smooth. I'd like to put on record. Now, of course, the qualifications, etc., put them in a good position, so they should be given more consideration.